Okay, so can you hear me now, everyone? Sorry once more about the problems. It was all my fault, not Professor Nunes' fault or anybody else's fault on the Brazilian side. I just had the window open twice, so that's why I was hearing myself double, but now the problem is gone. So we can finally start with modernization. And as I already said, this is a very, very complicated term, of course, and it's a very contested term as well. And many people don't like to use it, and it's been subject to much critique. It comes originally from Max Weber, one of the founders of sociology, who was, by the way, of course, a lawyer himself. He wrote his doctoral dissertation actually on Roman law. And another big name in the early history of this term is the North American sociologist Talcott Parsons. These two people have really created this discussion, which was very, very popular in the 50s and 60s. There was a lot of talk about modernization as a sociological terms. And it has sort of like come back during the past couple of decades. It usually refers to the 19th century, to many things that happened in that century. There's a move, according to Weber, from irrational to rational. The idea is that things before the 19th century were in administration. We're talking about the administration of states now, where it was more or less irrationally organized, then it became rational. There's a movement towards democracy. The individualist sort of like steps in the forefront of just about everything. Instead of the states, instead of social states, we talk about individualists. There's some other type of phenomena also going on, which have a lot to do with this other phenomenon, namely industrialism, commercialization, and secularization. Of course, the importance of religion diminishes radically in the 19th century. Now, this is all true, of course, more or less. But where does the critique then come from? Well, mostly it's a critique that comes from that's sort of like concentrated on the idea of Eurocentrism. When the theories of modernization were formed, they were based on what happened on Western societies, and mainly European societies. And then when one looks at this from some other angle, especially African or Asian angles, these modernization theories might seem a little strange. If one tries to sort of like make them fit the whole world, one runs into problems automatically. And if one tries to make the Western modernization theory sort of like a yardstick with which one then tries to measure the development, so to say, of all societies on the globe, one runs into problems. That's more or less the essence of the critique towards modernization theories. But still, there's something quite appealing to them, and I also tend to use the word modernization when I talk about 19th century legal changes. I call it legal modernization, even though actually this whole presentation is then sort of like a kind of critique towards some of the main ideas of legal modernization. Actually, you will then see how at the end of the presentation. The idea behind legal modernization, the way I see it, is that one, for one thing, moves from an ancien regime legal thinking to modern legal thinking. Ancien regime legal thinking meaning everything that was more or less before the 19th century, and then modern legal thinking in the 19th century. Now, what was legal thinking like before the 19th century? here we can, I've listed some names there who are very important writers in this field: Carlos Garriga, Antonio España, Victor Tau, and Massimo Meccarelli, who will be speaking tomorrow, although I suspect he probably will not be speaking about this thing, but he will be talking about something else. Anyway, the idea more or less is that before the 19th century, it was the judge that was in the center of legal decision making, not the law. It was the judge. This is Carlos Garriga's idea, actually. It was the law of the judge, more or less. The judge could use all kinds of legal sources. There was a huge amount of them in the early modern society to tailor-make a decision in a case. So one had a case, and then one sort of like the judge had to think, well, what would be the best solution in this case? This is, of course, an ideal situation I'm describing here. What would be the ideal decision? What sources can I use? What sources do I need? Do I need customary law? Do I need Roman law? Do I perhaps need some statutory law? Or can I take recourse to the Bible, maybe? There were many different sources available, many of which also could be contradictory. One source says one thing, and another source says another thing. So it was the judge who decided what to use and how to use. That's why much of the legal theory also concentrated on what the judge should be like. But this is so-called theory of the perfect judge, Judex Perfectus, which Carlos Garriga also has described. He's Spanish. Antonio España, whom you probably know by name, he died a couple of years ago, unfortunately. The great name of Portuguese legal history, has also talked a lot about these things, as has Victor Tau, who is then the grand old man of the Argentine legal history. From the movement from this casuistic legal thinking to sort of like the reign of the law. Massimo Meccarelli has a brilliant book on the judges' arbitrium, arbitrary powers of the judge. Back then, in the early modern period, arbitrariness was not a bad thing. It has gotten that kind of a sort of like a bad connotation only later. Back then, it was the judge's arbitrium, the judge's discretionary powers, one could also say in English, that also got a lot of attention, which Professor Meccarelli then describes in his book. So from judge to law. Now, in the 19th century, the center point of attention is moved from the judge to the law. Now it's the law that becomes the central thing. One thinks that law, and not just any kind of law, but written law, that should contain everything, so that it really should become not irrelevant, but much less relevant than before, who the judge is. As long as the law is good and it's clear and it's well made, then it plays less of a role who the judge is, what kind of a person the judge is. And that then brings us to the idea of codification. Codification becomes sort of like an ideal form of law, an ideal form of written statute. If everything is in one book, that's sort of like a heaven for the 19th century legal thinker. Could I have the next slide, please? Okay, so we came to the codification in the 19th century. Nationalism is another important hallmark of the 19th century, which I still did not mention in the previous slide. Of course, the whole phenomenon starts much earlier, actually, if we want to be exact. It starts more or less in the 13th century with some nations in Europe, England, France, Sweden, for instance, are quite, well, maybe not France, maybe you cannot call that a national state, But England and Sweden are moving slowly, at least towards that direction. 16th century is another important point of development, because that's more or less when there's a big change, of course a gradual change that as well, it doesn't happen overnight, but it's a change where one moves from the feudal system of the medieval times to something which looks like a modern state. If you have ever looked at a map of medieval Europe, you will probably remember that it's very hard to remember anything about it, because it looks like a quilt. It's full of these little areas, and there is not really, big states which are sort of like easy to remember, that France is there and Italy is there and England is there and Spain is there and stuff like that. No, instead of that, especially the German area, the Middle European, Central European area looks really difficult to fathom what's there. This is because of the feudal system. There are all kinds of little states which are in all kinds of relationships to one another. Some rulers are vassals to other lords, who are then vassals in turn to their overlords, and so forth and so forth. So that it's really difficult to even show that in a regular map. It doesn't. Modern maps don't really portray very well the medieval feudal system. Now in the 16th century, there's a development towards a territorial state, which then becomes especially clear after the Peace of Westphal in 1648, when modern type of territorial states more or less start to take shape. You have a state which has a clearly defined territory, and there is a ruler who is sovereign within that territory. Basically, that's when the modern states more or less start forming. The French Revolution is often seen as some kind of a starting point for the 19th century nationalism. That's a little bit, a few steps ahead of what we had before. Because now one consciously starts to develop nationalistic ideologies, or more or less consciously at least. And they typically consist of certain things. You have, as said, the territory, of course, clearly defined territory. We know more or less clearly where you have Spain. Now Spain is no longer divided into all kinds of little kingdoms. It's Spain. Oh, I forgot Portugal, by the way. Of course, I should have mentioned Portugal as one of the earliest examples of national states. Actually, that of course is probably the first European national state already in the 12th century to 13th centuries, around the same time as England, and even more clearly, as you of course know better than I do. Anyway, in the 19th century, you start having all these things. You have the territory more or less everywhere. You often have, at least you would, if you're a 19th century nationalist, think that you would like there to be just one language in one country in Europe. Of course, that doesn't succeed always. We have these strange cases where you actually cannot decide which would be the right version of the language, like Norway, for instance. Norway basically has one language, which is Norwegian, but still today, because they haven't been able to decide, they have two versions of it, two dialects, which both have an official position. But basically, language is one of these things. History. You create a history for the nationalist states. It doesn't. It's not something that comes automatically. It's really being shaped and made for each country. Scientific history is really something that is born in the 19th century, and it is born as a nationalist history in the first phase, which is interesting, of course. Every nation has a history, and it's something that's being created then. Well, of course, then art as well, poetry, music, paintings could be added to that list. Every country creates their national pantheon, more or less, of poets, musicians, composers, authors, of course. Literature is a very, very big part of that, and so forth. So that we know, for instance, what Brazilian poetry is like. What are the major Brazilian writers from the 19th and 20th century? We know that it's part of your literature, and something that's also been created. In some countries, they even issue lists of what every citizen should know of their country's literature. At least the Dutchmen have, I think, such lists, which are being updated, of course, and debated regularly. It's interesting. Flags and national hymns belong to the same category. And then law. Every country should have its own law, according to the 19th century nationalist thinking. And that law has a history as well. So legal history is also born as a very, very national enterprise at that point. You have law which has a history which extends back, in some cases, then hundreds of years. That's a very, very nationalist-minded way of thinking about law and legal history, which is now born. And that's, of course, then that national law is then codified in these codifications. Even though we know, of course, that they weren't that different, because we talk about private law codifications, in fact, more or less all of the at least the continental private law systems all stem more or less from Roman law. That has a lot to do with English law actually as well, which was not that different from the other ones, as is sometimes claimed. Again, by the way, by the English legal historians, who went into great trouble at the end of the 19th century to make it clear for themselves and for the other ones as well that English law was something very, very different from continental law. Today, legal historians do not deny that, but we tend to think that there's a lot of exaggeration in that. Much of those differences were actually creations of the 19th century. Okay, let's go to the next slide. Private law codification. We're talking about that now. We will leave the other codifications out of the question, but much of what I'm saying about private law codifications actually could be applied to the other ones as well, but not everything. Now, the idea of codification, of having a book which contains more or less all law, comes from natural law and the Enlightenment thinking. Natural philosophers of natural law, Samuel Pufendorf and Christian Wolff, created systems of their own, sort of like hierarchical systems where one has some sort of like other concepts, and then one leads the other concepts from those concepts. Like Pufendorf had the concept of socialitas, sociability, the idea that people are basically social and they basically should get along with each other. And from this, he then led all kinds of ideas, legal ideas, like, for instance, contract. Of course, if we like to get along with each other, then we can have something, an institution like contract. And if we get along with each other, then we need criminal law, which then regulates situation where this principle is broken, and so forth and so forth. You can well imagine how entire legal systems can be derived from the idea of sociability. Christian Wolff, similarly, he was even more mathematical than Pufendorf. But these were philosophical systems, really. They were not laws anywhere. However, they then served as models for 19th century codes, which actually were then made. Jerry Bentham should be mentioned as one of the major ideologists of legal codification in the beginning of the 19th century. Although he never really managed to do much about that in his own country, England. A little bit of a paradoxical situation, but he was nevertheless a very, very big ideologist as far as codification went international. Germany had the famous strife about this so-called codification strife between two famous professors, Brigitte Savigny and Antonius von Thibault, who had a fight about this for years. It was Thibault who thought that Germany, even though it was not a united country at that point, of course, there was still about 30 different states, of which the Deutsche Bund, the German federation, consisted of. But actually, just because of that, Thibault thought that well, it would be a good idea to at least have a codification, like the French had just issued, which could then unite these couple of dozen of German territories. Savigny, who then won this struggle, thought otherwise. He thought that the time was not yet ripe for such a codification. He thought that one should first build some kind of a unitarian system with the help of legal science, legal scholarship. He's often we often think of Savigny as the founder of modern legal science, in fact, because he was then from his thinking and the thinking of Gustav Hugo and some others that modern legal scholarship, modern legal science actually grew. Then a few codifications of private law should of course be mentioned here. I'm not going through all of them because that will take many lectures, and I'm sure you've actually heard about these already in your own lectures. So I will just limit myself to two, actually three there, the list. So Code Napoleon, because it was very influential. It was actually the first modern code. There were some others before that in Prussian and so forth. But Code Napoleon is the first very modern code in the sense of being quite succinct, quite short. It didn't have thousands of paragraphs anymore, as did some of its predecessors. It was quite corresponded quite well to the scientific ideas of that time, and it basically contained all law in France, in the area of private law. It theoretically and also in practice very much sort of like wiped out all the customary law systems, of which in some areas of law one had hundreds in France at that time. For instance, in inheritance law, you could have a little bit of a different system in almost every village. No longer after Code Napoleon. You had just this one law which unified the whole private law system in the country. Forbidding actually also all kinds of the importance of legal practice, at least in theory, although then legal historians have also showed that it wasn't quite like that in reality. Legal practice has had importance in France ever since, although not theoretically as clearly as in some other countries. Code Napoleon is then being followed in many other countries, in some countries in Europe because of Napoleon's conquests, but in others just because it was so good. It was a quality product, which if one wanted to have a codification in private law, which many wanted, it was a good idea to more or less, well, maybe not copy Code Napoleon, but take it anyway as an example, which one then could modify to suit the interests of one's own country. Same happened, of course, in many countries in Latin America as well, as you well know. German Civil Code 1900, about 100 years later, is another big example. Of course, there's 100 years difference with these laws, and a lot had happened, a lot of systematization and lots of legal development, a lot of many societal changes as well. So it's a very different law, but it's nevertheless a very influential law that as well. And I just put Brazilian Civil Code there as well, which you of course know from 1916. It was quite a late code actually. I've understood that there were some problems there were discussions already in the 19th century, but they just never came to anything in Brazil before 1916. Now, codification has been deemed a very, very important thing in the history of Western law, up to the point that I'm citing Pio Caroni, who is a Swiss famous legal historian, a very, very good legal historian, although I'm criticizing him, it doesn't mean that I always do. I think I respect him very much. He's a great scholar. But he said that the code to the road, the code was the road to the modernization of civil law. It was an epochal turn in European legal history. Well, that's true, but it's not the whole truth, as we will see in the next slides. Could I get the next slide? Thank you. The funny thing is that although almost everyone, many countries, let's say that way, decided to adopt the codification according to the French model, according to some other models, but a codification nevertheless. Many did not. And there are certain groups which did not codify their laws. You have the Nordic countries, Denmark, Finland, Iceland, Norway, and Sweden. That's the first major group which still doesn't have their private laws codified. What they did have, that this might sound a little bit paradoxical maybe, was a long tradition of statutory law from the Middle Ages onwards. So in these countries, you've had provincial laws from the 12th or 13th century onwards. Norway was always the first. The medieval laws date to the 12th century, and then Denmark and Sweden come after that. And then you have to understand that I'm not talking separately of Finland and Iceland, because Iceland was a part of Denmark until the 20th century, and Finland was part of Sweden until the 19th century. So the Swedish laws were enforced in Finland as well. And Iceland has a little bit of a more complicated history because it also has its own medieval laws. But let's not get into those details now. The idea is that there was legislation in all of these countries from very early on. And then, although those were provincial laws, mostly in the medieval period, then in the early modern, there come these big law books. The Danish law, 1683, which basically contained almost all Danish law. The same with Norwegian law, which was practically a copy of the Danish law, should be say there, by the way, 1685 and not 3. It was 2 years later, because it was actually more or less of a copy of the Danish law. And then Swedish law, 1734, which was also basically contained everything of the Swedish law, and except for the constitutional side, which was left out of it, and police regulation, which was not there either. But it had private law, it had criminal law, it had procedural law, and all that. So there's a strong tradition of statutory law, but they did not codify. And I'll get to why they did not do that quite soon in the next slides. And then the common law countries, obviously, they did not codify either. England, the USA, and the others, they did not make any codifications. And one should not forget Germany, which took a long time until it codified in 1900. Switzerland, and there are many other countries as well, which took a long time codifying, although they then finally did it. There were discussions in all of these countries practically about codification. That was the question of the day. That was sort of like the discussion topic of the period, and especially in the beginning of the 19th century, and practically all along the century. If you did not codify, you at least discussed, should we codify or not? And there were all kinds of arguments back and forth against and for the codification. But what's important from the point of view of this presentation is that all of these countries mentioned here, even though they did not codify, their laws as the contents of the laws were considered still modernized, in the sense that they created the same kind of a legal framework for the modern capitalist, commercialized, secularized, democratized, and so forth state, as did the codifications in those countries where they had codes. So it does not seem to depend on the codification whether the legal systems were modernized in the sense that I described in the first slide. Then what was it that was important here? The important thing, and that's actually one of my major points in this whole lecture, is the legal science. It was the legal science of the 19th century that spread from Germany originally to practically all parts of the world, which became the common language for the lawyer everywhere in the Western world, and also partly in other parts of the globe. It was not so much the codification as it was the legal scholarship. It was the same kind of Begriffsjurisprudence, same kind of constructive jurisprudence, which was prone of making hierarchies of legal concepts that spread also, for instance, to the Nordic countries. The same German type of legal science. And of course, the whole German legal science developed without codifications all along the 19th century, although it then led actually to the codification in 1900. But all during that century, they could do everything that a modernizing state or modernizing territories, in the case of Germany, were doing elsewhere, but relying on the legal science. In Germany, it was really the legal science that came to unify the country already before the unification of the German state in the 1870s. So legal science is very, very important here. Could I have the next picture, please? Thank you. Now, why were codifications then made if they were not absolutely necessary for the modernization? Well, first it must be, of course, said that even though they were not absolutely necessary, of course, they helped in that work. I mean, they had importance for the modernization. There is no doubt about that. But what I'm saying here is that there were other reasons for codifying, and there were other reasons for not codifying. We cannot look at these things only through the lens of modernization. This is my critique towards the theories of legal modernization. There are other things concerned. For instance, the code as a national symbol. The codes became strong national symbols in all of the countries which codified. France being maybe the prime example. The French code, the Code Napoleon, is almost as powerful a symbol as the La Marseillaise, the national hymn, or the French literature, or whatever you have, the tricolor, the flag. It's a very, very strong national symbol. And this is the case in many other countries as well. But you didn't need that necessarily as a national symbol. You could also have other things. In the case of the Nordic countries, you had the laws in Norway and Denmark from the 17th century, and in Sweden you had the law of 1734, which served very well as a national symbol in the 19th century as well. One did not need another modern codification to serve as a national symbol because you had these old laws. By the way, still today, some of the old laws are being printed in the books, in the law books of all of these countries, not because they would be enforced, but because they serve as symbols. Well, of course, then another thing is that nobody uses law books anymore. We still did it when I was a student in the 1980s, but of course they almost disappeared now as in the form of book. I mean, our students just read their laws from the net, as you probably do too. But that's another thing. But one of the reasons for codification in the countries where it was done is a little bit more, so to say, well, not deeper, because being a national symbol is also a good reason. But it had to do with the chaotic state of the ancien regime law. Now, what does that mean? Well, with a chaotic state, I'm referring to the system that I described in the beginning, where the judge was confronted always with a huge amount of different legal sources, stemming from different rule givers: the state, the church, the towns, customary law, the law of the merchants, and so forth and so forth. There were a huge amount of different legal sources available. And that worked in an estate-based society, which was divided into nobility, clergy, bourgeoisie, and so forth, which all had their places in the society. It was okay. But when one comes to the 19th century, one starts to demand something else of the law. One starts to demand foreseeability. One must be able to more or less foresee what a decision in a certain case will be. And then you cannot cope with the chaotic system of legal sources anymore. You demand something else. You need codification. No, you need at least clear law. At least clear law, and clear law often is very close to the idea of codification. Now, why did the Nordics then not have this? Because the Nordic countries were special in the sense that there really was no chaotic state of legal sources up here. In that sense, the Nordic countries were different. They had quite simple societies, which for hundreds of years had already been governed mainly by written law. Well, there was something else, of course. I'm exaggerating here, but there is a difference. And that kind of a chaos, which was the order of the day in other countries of Europe, just was not that bad in the Nordic countries. So one could still cope with the old laws quite far into the 19th century. At the end of the 19th century, they of course were growing old, and one had to replace them, but not through codification. What one did and still has been doing all these years is partial legislation. One has a law, for instance, for obligations. One has another one for inheritance, and so forth. So the Nordic countries do not have a case law system. These are not common law countries. It's the written law which is fundamentally important, also in private law. But it's in bits and pieces here and there. There is no one big codification for these reasons, because it was not considered necessary in the 19th century, because one already had the national systems, the symbol in the old laws, and there wasn't really no chaos as to the state of legal sources. US is a different thing. Now, what happens there is that the case law, you know that, of course, that the common law system is based on cases, and that worked still in England, which was a small country, a relatively small country anyway, but it did not work in the long run in the United States. Why? Well, because the country grew. It grew territorially, geographically, and it grew demographically. There was more land and much more people. There's just one example of the case reports which were issued in the United States from the beginning of the 19th century in the form of separate books. So there were volumes of case reports. In 1822, you have 140 of those, which was already much more than before. Then the figures just rise exponentially. 1839, you have 500 of them. And in 1882, you have almost 3,000 volumes of case reports. Now, who can read all those? Who can claim to really, really master all of those cases? No one. And this is something that a famous professor, the dean of the Harvard Law School, Christopher Columbus Langdale, wanted to do something about. He just couldn't stand anymore trying to teach his students all these cases, and he comes up with an idea of leading cases. He chose, quite arbitrarily actually, at least partially, cases that he thought were important. He systematized them, he harmonized them, he demonstrated them as a logical system, and he published those leading cases with explanations as books. And this is the method which then leads to the so-called American legal formalism, a formalist system which makes this chaos of case law much more manageable, much more understandable. It becomes possible to teach it to the students. It becomes possible to learn it. It becomes possible to use those cases in courts. More or less everyone knows now what the leading cases are, what the important cases are. Of course, it goes without saying that in the common law system, nothing stays as it has always been. The system changes, but it changes after legal formalism in a much more controlled manner, at least. Now, this legal formalism is very much related to constructive jurisprudence in Germany. Begreffs jurisprudence, conceptual jurisprudence, which is then something a very similar way of thinking about law. What they do in Germany is they do not make the formalist system out of cases so much, they make it out of Roman law. Roman law as it was enforced in Germany in the 19th century. Mixed, of course, with German law, which comes from the Middle Ages and so forth. But basically, the heart of the system came from Roman law, which was then applied to meet the standards of the 19th century. And this idea of making a system of these legal rules is then something which is exportable to all over the world, so that everybody goes to Germany to study law in the 19th century. The Nordic people go there, the Russians go there, the Japanese go there, the Brazilians go there. Not everyone, of course, but of these countries, but everybody who wants to be something in law goes there to study this system, and then imports it to his it was always a he, of course, at that time, to his own country, and then on the basis of that scholarly thinking, on the basis of that legal scientific thinking, then constructs the system of their own country. And maybe then there's codification and so forth. So what both North America, the common law system, and the continental systems have in common is a legal formalist system. In America, it's just called something different. It's called American legal formalism. In the continental system, it's called constructive jurisprudence. But these two have basically a lot in common. They are both systems which are created to meet the needs of the 19th century society, which expects foreseeability from their legal systems. They expect that the legal system be able to give clear-cut answers to legal problems, at least relatively clear-cut as law ever can be. Of course, this is very relative, as you all know, of course. So this is the idea, and I think I still have one slide, at least. Yeah. So just to conclude, codification was admittedly, and of course, it was one path to legal modernization, but not the only one. There were other ways of doing that as well. The Nordic countries had one solution, partial legislation, and the common law countries, especially the United States, had their own way of making a legal formalism to meet the standards of the 19th century. What's behind both of these movements, both in America, in North America, in the United States, and the continental law countries, is that it was really the legal scholarship which stood at the heart of the change. It was the legal scholarship which really designed and formed legal formalism all over the Western world, regardless of whether we're talking about countries of the continental tradition or the countries of common law tradition. Legal scholarship really became more or less, and legal formalism became more or less a common language for lawyers everywhere. And that's really all I had to say. I'll be happy to answer any questions you might have. Thank you.
Thank you, Professor Heikki Pihlajamäki. Muito obrigado. Professor, vou me permitir falar em português mais devagar, sim, que eu sei que o professor compreende bem, assim podemos também reagir com mais pessoas. Também é interessante pensarmos, e aqui começo meus comentários, muito interessante a proposta do professor em justamente demonstrar como funcionou esses outros caminhos, essas outras propostas, essas outras vivências, que não aquelas clássicas da Europa continental, as quais fazem parte dos nossos manuais de história do direito. Imagino que o professor, enquanto alguém que ensina a história do direito em um país nórdico, assim como nós que ensinamos história do direito em um país latino-americano, temos grandes dificuldades em alguns momentos em nos enxergar, em nos vermos naquela história. A grande questão que me parece e que o professor consegue conjugar muito bem aqui, inclusive em alguns textos anteriores que eu já tive a oportunidade de ler, é perceber como que essas questões podem caminhar em comum. Ou seja, entender que, de certo modo, essas histórias são histórias conectadas, histórias cruzadas, ainda que não sejam necessariamente as mesmas histórias. Então, me chamou muito a atenção, talvez esse seja o ponto principal aqui da sua conferência, o papel da ciência jurídica. Tá? E aqui eu vou lançar uma primeira pergunta ao professor, para tentar entender, aprofundar um pouco mais esse argumento. Não sei exatamente como funcionava a realidade das faculdades de direito, das universidades nos países nórdicos. Posso falar da experiência brasileira, que inclusive, como o professor também bem sabe, é muito diferente daquela latino-americana em geral. Ao contrário dos espanhóis, que trouxeram e criaram universidades e faculdades de direito no espaço latino-americano, pensemos desde já em Lima, cidade do México. No Brasil, apenas com a independência, tivemos faculdades de direito. Ou seja, até então, os brasileiros ou portugueses que viviam no Brasil se formavam em Coimbra, em Portugal. Então, quando nós temos a independência do Brasil, no começo do século XIX, e posteriormente a emanação de alguns códigos, primeiramente o Código Criminal e o Código de Processo Criminal, e, em um segundo momento, o Código Comercial, apenas uma parte do direito privado, tá? Ainda assim, mesmo com os códigos e mesmo com as universidades, o estilo dos juristas brasileiros, quando escreviam, daqueles poucos que escreviam, não era um estilo, como podemos assim dizer, acadêmico, no modo mais tradicional. Eram textos muito técnicos. Nós temos muitos comentários a esses códigos na primeira metade do século XIX, mas nós não temos tratados jurídicos propriamente dito. Então, eu gostaria de ouvir um pouco mais essa questão do professor. Como que, por exemplo, a partir da experiência nórdica, o senhor enxergava as universidades e as faculdades do direito fazendo isso? Porque quando nós encontramos essa questão no Brasil, os comentários a esses códigos, quando queriam discutir alguma coisa sobre ciência jurídica, em geral, acabavam se remetendo aos pensadores canônicos, como o professor ali mesmo referenciou, Jeremy Bentham, Pufendorf. Por exemplo, o livro de Direito das Gentes, adotado oficialmente nas faculdades de Direito, em primeiro momento, era Vattel. Ou seja, pressupunha-se, por exemplo, que um estudante de Direito deveria saber ler francês e, portanto, ele poderia ler as traduções francesas de Vattel, de Bentham e de outros autores. Então, eu gostaria de escutar um pouco mais do professor, como que funcionou esse contexto nos países nórdicos, se eventualmente tinha um influxo mais próximo da Alemanha, por alguma mínima comunidade linguística e proximidade geográfica, ou se tinham outros meios pelos quais se alimentava essa ciência jurídica em países sem codificação.
Okay, very good questions. Well, it's okay. Yeah. Where should I start? Well, about the legal faculties, of course, there were legal faculties from quite early on. They were much older than the Brazilian faculties, but not as old as, for instance, you mentioned the University of Lima, San Marcos. It was founded in the 16th century. The Swedish ones come from the 17th century. But then one has to understand what the legal faculties were like. There were several of them that were founded already in the 17th century. But up until the very end of the 19th century, it's very typical that they only have one professor, maybe two. And you can imagine that with that type of staff, you can only teach. You don't really produce scholarship. And that was more or less like it. There were very, very few books written in the 17th century. You have maybe, you can count them with hands with fingers of two hands. The same with the 17th century was actually even worse in Sweden, because we had the code of 1734. That sort of like emptied the whole thing, you know. I mean, you had nothing to write about because you had the modern law at that time. So the 19th century, then Finland becomes part of sort of like an autonomous state within Russia. And towards the end of the 19th century, it starts having its own literature, but it's still very, very little that there is. And just like in Brazil, also here, it's very much of copies of what's being written elsewhere. And also here, quite technical writings, practical guidebooks for lawyers working in courts or judges. Now, one other thing, which I think many peripheral areas in relation to Western Europe, which are Latin America, Nordic countries, Eastern Europe, so about half the world, half the Western world. We're not even talking about Africa or Asia. We're talking about these areas. In many of these areas, you have a very limited number of legal professionals, lawyers who have studied in the universities. And this is also typical for the Nordic countries, that you do not have university-trained lawyers in huge numbers. In many legal professions, you don't really have, for instance, educated advocates until in very small numbers at the end of the 19th century, beginning of the 20th. But up until the 1980s, you had large areas in Finland. Just about four decades ago, when it was difficult to find a university-educated advocate if you needed one. So it's, and I think we still have, Sweden and Finland still have one of the lowest numbers of lawyers per capita in the whole Western world, actually, because of this long, almost lawyerless tradition. We don't have many lawyers. It's typical for these countries. That's a bit of another story, but it has to do with this, what you asked about. So this makes it kind of interesting, because I often, because I'm very, my current research project is actually on colonial law. What I'm interested in is colonial law of Portugal, Spain, and the Netherlands. And I often think about, when I think about the colonial legal systems of those countries, I sort of think of the Nordic countries as not as colonies, of course, but in many ways related to the colonies, similar. And it has to do especially with the way legal history is written. It's really Eurocentric, and not even Eurocentric, but it's Western Europe centered. That's why when we read the typical course book on European legal history, it sounds a little bit strange to us, because it's partly our history, but then it's not really our history. And I think it must be a little bit of a similar feeling when you, as a Brazilian legal historian, read legal history course books written in Europe. You must have the feeling that, well, interesting, but this is not really my story.
Exactly. Thank you. Uma segunda pergunta que eu faço, é um comentário, mas eu gostaria de escutar mais o professor sobre isso, é tentando conectar algumas ideias centrais que o professor trouxe hoje com algumas que a professora Mia Corpiola trouxe ontem. Ela discutia de modo específico a questão dos veículos, dos meios de transporte e a modernização do direito a partir disso, mas ela trouxe um elemento muito importante, que foi o paradoxo de, em várias situações específicas, as antigas normas de polícia, Polizei, que acabavam resolvendo algumas situações específicas. E ela comentava desse paradoxo da modernidade, que por vezes precisava se valer de um direito antigo para resolver problemas muito atuais. E no Brasil, de certo modo, nós podemos enxergar uma espécie de paralelo, dadas as circunstâncias, com relação ao regime de escravidão que você tinha aqui. O Brasil se torna independente, faz leis modernas, códigos, como eu citei, os códigos penal e de processo penal, como também o Código Comercial, e, ainda que não tenha tido um Código Civil completo durante o século XIX, ele teve uma série de leis modernizadoras no direito privado a tentar resolver isso. Para além do Código Penal, do Comercial, eu cito duas. A chamada Lei de Terras, que discute a propriedade do território, acabando com o antigo regime de sesmaria, de uma ocupação pela posse, como também a lei de hipotecas, que dava a possibilidade do uso dessas terras como garantias para negócios capitalistas, inclusive incentivando a construção, criação de bancos e outras coisas nesse sentido. Por outro lado, escravidão continuava a ser um meio de trabalho de produção principal, né, especialmente nas culturas agrícolas, do café, da cana-de-açúcar, que eram os motores da economia. E todo esse arcabouço jurídico referente à escravidão, muito dele ainda era direito romano propriamente, nem mesmo direito colonial, no sentido de normas das ordenações ou normas específicas, mas questões como a liberdade eram resolvidas com os antigos institutos da manumissão, do direito romano. Então, eu gostaria de escutar mais um pouco do professor. O professor também comentou, em alguns casos, quando falava dessa resolução parcial que as leis nórdicas davam, ou seja, elas eram leis modernas, mas resolviam parcialmente os problemas. Isso significa que outra parte ficava com as antigas normas, ou com as antigas tradições e costumes. Então, eu gostaria de escutar um pouco mais do professor acerca desse paradoxo da modernidade, que se valia também de direitos antigos, tradicionais, para tentar resolver problemas modernos, em conjunto e convivendo com novas legislações, como os códigos, ou mesmo essas leis modernas que o senhor exemplificou do espaço nórdico.
Well, yes. In a way, first of all, I would say that most of the field was really covered by new partial laws in the years between 1860 and 1880. Those 2 decades were really fundamental in creating the sort of a framework for a liberalist, capitalist society, whatever you want to call it, which is more or less freed of the old limitations. So one is now free to move where one wants to go, and there's more or less equality between men, at least, and so forth. So there's a sort of framework which includes certain laws. For instance, hypothetics here as well. The banking laws, which are of course important. You need banks so that you can collect money from the public and then have it invested. And there's legislation on money as well. There's legislation on obligations. There's a law of obligations, which a little bit later, but anyway, more or less in the same compound and so forth. What there is not is a separate commercial code or a commercial law. That stays more or less as it was regulated in the law of 1734. And that was possible because it was not very much regulated. There were quite loose rules actually that one had in the law of 1734. So what comes in its stead is really legal practice in that particular field. Legal practice and legal science, legal scholarship, which again comes very much from Germany. So in that field, you just let the old rules be, because they're not very good, but they're not very bad either. They don't really say much. And in fact, some of those rules were still in force a few years back, because they didn't really disturb anyone. They were not very useful either, but they were just there. So nobody had much interest in really taking them out of the law book either. So in some fields it was like that, but I would say in most of the fields there were the partial laws that came really to regulate these areas.
Thank you. Muito interessante. Professor, nós temos uma pergunta do público que nos assiste pelo YouTube. Eu vou colocar aqui no chat, mas também lerei. O professor pode acompanhar. A pergunta é da Márcia Mangili. No Brasil, a defesa da codificação por Bevilacqua, que é conhecido como autor intelectual do Código Civil de 1916, se conciliava com a liberdade dos juízes para decidir de acordo com as necessidades sociais do tempo. A defesa da codificação convivia com a defesa dos princípios gerais de direito, que foram identificados por Bevilacqua no começo do século XX como direito natural. Como foram tratadas as fontes subsidiárias de direito na codificação europeia?
Okay, so natural law. Okay, let me read this. I have to read again now. Okay. Well, I'm not sure if we can speak of Europe as one entity here. Well, again, in theory, in France, as I mentioned, it was really only the law, the written law, the Code Napoleon that reigned. But that's, of course, not the whole truth, as we know. You have, in principle, maybe not natural law as such, but you have legal practice, and you also have legal scholarship in the 19th century. Not as strong as they are in Germany, but you nevertheless have them there. Germany is then a whole different story because they don't have a codification until 1900. In the other countries, now I must really say that I don't really know what the situation was in Southern Europe, in Spain or Portugal or Italy. I'm not quite sure, but I suspect that natural law still had some kind of a place there as well. One thing is that sometimes one talks about natural law, sometimes one talks about general principles, and they amount to more or less the same thing. That's one thing. And we have the general principles up here in the north as well, alongside the written law. So the general principles of law are there. Actually, almost until the end of the 19th century, there are still also legal scholars who talk about natural law, but then it disappears. I think it disappears quicker from the north than from the south. So in that sense, there are subsidiary, maybe not fonts subsidiarias, but at least principles that guide the use of legal sources. But maybe Professor Nunes knows more about the system in Portugal in the 19th century or Spain. Was natural law important there? I don't really.
Creio que quando ela fale de fontes subsidiárias, ela queira justamente discutir o papel do costume, da jurisprudência e dessas outras.
Yeah, all right. So we're actually talking about really real sources of the law. Okay. Well, customary law is interesting because it stays there as some kind of a source. It's actually still in Finland. At least in theory, it's at the same level as written law. And there are some places where you actually have customary law still. In some areas of law, it exists in Finland. But in practice, of course, what happens in all the countries in Europe is that customary law, even though in principle it may still exist, in theory it may still exist, its area diminishes because legislation takes over the whole field practically. So that's why customary law tends to diminish everywhere. The same happens with moral theology. There's a great book by the Italian historian Paolo Prodi who has written about how moral theology as a normative system sort of like diminishes all the time until it really becomes into almost nothing in the 19th century. The secularized society, you don't really have one moral theology anymore, which would have any important meaning in the society. So in that sense, but of course, then there are other sources. One of them is legal practice, the practice of the high courts, and then there are big differences there. In principle, again, the French Cour de Cassation basically is not a legal source. In the Nordic countries, they are a source. The high courts are a source. The legal practice is an official source according to legal scholarship. And then there are all kinds of differences there. But what's really important is that in every country in the Western world, what there comes in the 19th century is a system of legal sources. There's a hierarchization of legal sources, and what they all have in common, whether it's Brazil, Finland, Germany, or Spain, it's always the written law, the statutory law that's at the top of the hierarchy. Then there are differences in different countries as to whether you also admit legal practice some kind of a place in the hierarchy, whether you accord a place to legal scholarship, whether that can be a source. In some countries yes, in some countries no, whether you give any weight to the travaux préparatoires, the preparatory documents of legislation, and so forth and so forth. There are differences as to that, but everywhere it's the written law. And the interesting thing is really that you now have a system of difference of legal sources. That's the 19th century thing. Before 19th century, you didn't really talk about legal sources in the modern meaning of the word. There was not a closed system of legal sources as there is since the 19th century everywhere.
Ok, muito obrigado. Temos uma segunda pergunta que eu vou colar aqui no chat também, um pouco mais longa, e vou fazendo a leitura, o professor vai lendo também. A historiografia do direito aponta que um dos fatores que devem ser considerados para a não edição de um Código Civil no Brasil, segundo comandava a Constituição de 1824, foi a escravidão. Teixeira de Freitas, o jurista contratado para a realização do projeto, ficou conhecido por sua oposição em codificar relações civis escravistas. Entretanto, a sua consolidação das leis civis foram importantes para a sistematização da legislação civil, além de leis que passaram a regular contratos de trabalho. Gostaria de saber se o professor considerou este fato para análise do caso brasileiro na demora da codificação civil.
Whether what Teixeira de Freitas did had an effect on the fact that that the codification was late.
Yes, because Teixeira de Freitas was contracted by Brazilian government in the 1850s, more or less, to write civil code to Brazil. But he tried to write a consolidation. Actually, it's not a consolidation, it's a draft of a new civil code, because it's impossible. You did a consolidation using Philippines ordinance. So actually, he tried to create a codification draft. And when he presented this draft, he said, it's awful to me create legislation on slavery, because actually Brazilian scholars in general, we hate slavery, but slavery exists, so as jurists we need to deal with it. And Teixeira de Freitas said, we didn't have Code Noir on Brazil, so we leave them kind of limbo space, because we don't actually know what to do with the situation. I don't know if the minus questions actually is if professors knew about some of this situation.
Well, I wasn't aware of that, but of course, I mean, what it reminds me of at least one thing, which is that these are sort of like not easy jobs in the 19th century. It's not an easy job to write a codification, even though I said that, okay, many times they copied almost at least codifications from other countries, but it wasn't always that easy. So you could not, it was a quite a big task to do. And if the person in charge did not want to do it or did it badly or something like that, in countries where you had not much choice as to the people, as to lawyers who could in the first place be entrusted just such a job, if they did not do it, it could in practice delay the whole project for sometimes for tens of years. And this happened, by the way, in Finland as well. A little bit of a similar situation, although, well, a little bit at least, because when Finland became part of Russia in 1809, Russia was really very eager to codify its laws. The Russian Empire back then consisted of many different parts, and their idea was more or less to codify at least the Russian law and to codify the laws of some of the countries on the verge of the Russian Empire as well, which were part of Russia, like Poland, the Baltic countries, and Finland. And they gave then, for instance, to the Finnish, they formed a group of Finnish elite lawyers, academic lawyers and judges and stuff like that in the beginning of the 19th century, 1820s. And so they entrusted them the project of writing a code. Much the same as the Freitas had to do in Brazil. This was a couple of decades earlier. But what they did was they stalled the whole project. They just didn't do it. And the Russians were completely dependent on this group because they had no choice. You had to know Swedish, which was the language of the administration still in Finland, all during the 19th century. And all the major lawyers in the country spoke Swedish. The Russians did not. There was a language barrier. So if these guys in Finland did not codify the Finnish law, nobody would do it. And they didn't. There were many attempts. The Russians tried many times to get it going, but then they gave up in the 1850s because nothing happened. They just didn't want to do it. Why? Because they were afraid that the Russians would at some point step in and tell them what to do. And they were afraid that the Finnish law would be Russified, made Russian. So they thought it's better to not do anything. So we would get to keep the laws. So in countries with little competent codifiers, things like this can have an effect. I don't know if this is at all an answer to your question, but this is something that just comes to mind when I read about that.
De fato, muito interessante, especialmente esse último episódio que o professor narra das barreiras linguísticas, que já não era um problema necessariamente aqui no Brasil, mas que no contexto europeu, especialmente no que o professor narra, faz muito sentido. Temos uma última pergunta, professor, da Bruna, uma pergunta curta, porém me parece bastante desafiadora, né? Coloca em discussão propriamente o argumento que nós discutimos aqui hoje. O que o professor pensa das possibilidades e limites do uso da categoria modernização para analisar o fenômeno no presente? It's very interesting.
This is a difficult question. I've thought about it actually quite a lot. As I just said, from this point of view, from this corner of Europe, this, of course, what I just talked about is quite a small thing. It's just a small correction to the normal European narrative of 19th century, which is centers on codification. It's sort of like a side story. It's from the global perspective, it's not that important really. It's just an example of how Eurocentric, how Western Eurocentric legal history at times can be. But it's really, of course, from the global point of view of today, it's not a very, very big thing. The much bigger thing is can we use this Eurocentric concept of modernization to analyze, for instance, Afghanistan or Somalia, places like that, which where there are real problems today. Can we expect them? Is our expectation that if things go well and if we help them, will they continue on the path to modernization, so that one day, if everything goes well, they will reach the same sort of like level of modernization as some countries in the West have reached? That's of course the big question. And politically correct answer is, well, we cannot use this kind of a yardstick. We cannot expect them to modernize in the same way because they're so different. On the other hand, one might have as a counter argument, one might say that, well, which part of the modernization do we not want them to have? Human rights? That's a European invention. Don't we want Afghans or Somalians to have the Western human rights? Any of them? Like, for instance, the prohibition of death punishment. Don't we want them to have that? Don't we want them to have liberty of ownership? Is that something that can, of course, be a borderline case already? But these are very, very difficult questions, and maybe the right answer would be that of course we want them to have some of the things that the category of modernization entails in the West, but maybe as a version of their own, so that they can sort of maybe opt out of some of the things that we have, that we consider important. But then there are some things that we, or at least I personally, do not want them to opt out from, like the prohibition of torture, prohibition of death punishment, and things like that. Which I don't know if they. I'm not claiming that they are part of the Afghan culture, for instance. I don't think so, and not any more than they were part of the European culture still a couple of hundred years ago everywhere. So these are terribly difficult questions, but I would definitely not go as far as saying, let's put it this way, I would not go as far as saying that no, the European category, or let's say the Western category of modernization, has nothing to do with the rest of the world. Sure it does. Sure it has at least something to do. There are some things in it which are good and which I think should be globally accepted. Maybe not all of them, but many of the core area of what's good in the modernization. I cannot help saying that it should be for everybody to enjoy.
Exatamente. Talvez, particularmente para nós, historiadores do direito, modernização seja algo do qual nós não tenhamos como fugir ou escapar, justamente porque as fontes nos evocam, né, especialmente no período que o professor colocou, entre século XIX e século XX, como um clamor, como uma necessidade a qual aqueles homens daquele tempo viam. Né? E talvez para nós o grande desafio, como o professor tentou aqui nos expor hoje, foi justamente tentar entender quais são as razões e os caminhos possíveis de modernização, e inclusive com a questão da codificação é um exemplo bastante interessante, de como, mesmo nesse espaço hegemônico, né, da Europa, era possível já vislumbrar diferentes maneiras de dar conta, de resolver esse projeto jurídico, podemos assim dizer.
Exato. See, that's why I think we have to. That's an important thing you said, and I think widening that a little bit, we can say that maybe there are different paths in different parts of the world to the same goals which we have reached some other way. So we shouldn't expect them to take exactly the same path. There may be other ones, even though we may agree on the final goal. There may be some other ways of reaching that. So You never know.
Yes. Muito bem. Professor Heikki Pihlajamäki, muito obrigado. Passo a palavra ao senhor para uma última palavra, uma última saudação, agradecendo a sua presença, a sua disponibilidade em estar aqui conosco hoje.
Claro, muito obrigado a todos vocês pelas perguntas que têm sido muito interessantes, muito importantes. E acho que para mim tem sido uma coisa muito importante. Obrigado.
Para nós também, professor. Para nós também esse diálogo tem sido muito interessante. Para nós, como inclusive foi colocado aqui, dessa perspectiva dessas periferias desse contexto que se coloca como central, numa perspectiva global, de entender as possibilidades de melhor, né, fazer história do direito e melhor compreender esses fenômenos do passado do direito. Com isso, me despeço, né, de todos aqui hoje, agradecendo mais uma vez o professor Heikki Pihlajamäki, com certeza. Amanhã temos o nosso último encontro, desta vez às 10h30 da manhã, com o professor Máximo Mecarelli, que vai tratar especificamente da relação de inovação e o direito. Era isso, muito obrigado, até mais.
Ok, até logo.